I think Supreme Court is completely wrong, and they have really denied, relief which both Umar, Khalid, and Sharjeel Imam were entitled to in under the Constitution, under the law, even under the UAPA law, as also the law has been interpreted by the Supreme Court in series of judgments. So I must say, with deep sense of regret and a deep sense of I would say sadness, that the two learned judges whom I respect quite well, Justice Arvind Kumar and Justice Anjaria, have really, done a great disservice to themselves and to the institution of Supreme Court. Court has committed manifest errors and many errors. For example, court has said that it is bound by judgment of the Supreme Court Union versus Najib or something. It's a three-judge bench judgment, which was delivered by Justice Suryakant, present Chief Justice of India. In that judgment, the Supreme Court has very categorically recognized the principle that with even stringent provisions for bail under UAPA, or for that matter, earlier Supreme Court has said in TADA, Article 21 is sacrosanct so far as liberty is concerned. And therefore, when somebody has been in jail for a long period of 5 years, and the trial is not likely to see the day, then there is every reason why the liberty is seriously in peril, and therefore such a person must be let loose. And it is a shame that what is happening in the country today, that now virtually in entire country, judges are afraid to give bail to people, especially people belonging to minority communities. I can definitely say one thing, that I cannot guess when he will be able to come out. I cannot guess that. And this 1 year that Supreme Court has spoken about, I don't think anything will happen at the end of 1 year. And frankly, if they had to give 1 year, they could have released him today.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. Yesterday, the Supreme Court denied Umar, Khalid and Sharjeel Imam bail on the grounds that their case is different to that of the other accused and that the court is satisfied there is a prima facie case against them. So today we ask the question, was that the right decision, or has the court erred and acted unjustly against Khalid and Imam? That's the key issue I shall discuss today with one of India's foremost lawyers, the former president of the Supreme Court Bar Association, Dushyant Dave. Dushyant Dave, yesterday the Supreme Court denied bail to Umar, Khalid and Sharjeel Imam on the grounds that their case is different to that of the other 5 accused. So let me start by asking, is the Supreme Court right in making this distinction, or has it erred grievously and denied Khalid and Imam justice? Which of the two?
I think Supreme Court is completely wrong. And they have really denied, relief which both Umar, Khalid and Sharjeel Imam were entitled to under the Constitution, under the law, even under the UAPA law, as also the law has been interpreted by the Supreme Court in series of judgments. So I must say, with deep sense of regret and a deep sense of I would say sadness, that the two learned judges whom I respect quite well, Justice Arvind Kumar and Justice Anjaria, have really, done a great disservice to themselves and to the institution of Supreme Court by rendering this lengthy judgment, which proceeds on a completely, misreading of the constitutional protection in Article 21. It proceeds on a complete misreading of the provisions of the UAPA Act. It proceeds completely on totality of facts involving the case. And I would say, with great respect to the learned judges, that judgment is definitely perverse.
Let me quote from what the Supreme Court said yesterday. This court is satisfied that the prosecution material disclosed a prima facie allegation against the appellants Umar, Khalid, and Sharjeel Imam. The court came to the opinion that prima facie the allegation is true. This is the first reason for denying bail. Do you share that understanding of the prosecution material, that prima facie it is true?
See, Karan, this case requires to be looked at it, very intensely. The charge against this group of people is that they were responsible in engineering some kind of riotous situation which led to deaths of 54 innocent Delhiites, and that they endangered the security of the country, and that therefore they were likely to embarrass the visiting Mr. Trump to Delhi on 22nd and 23rd of January of 2020. This whole case is very, very, I would say, it proceeds on completely wrong premise, because, the CAA protests were absolutely peaceful. We all know that. The Shaheen Bagh protests were very, very peaceful. The Supreme Court had to, order them to be removed, because Supreme Court felt that perhaps, they were obstructing traffic, but which was completely wrong order of the Supreme Court, in my opinion. Because right to protest is a fundamental right, and nobody can really, be, ejected from. But anyway, these protests were absolutely peaceful. Now, how did they become suddenly turn violent? That's something which the police has failed to tell the nation. And they turned violent, and I will tell you why. Because on 27th of January 2020, Mr. Anurag Thakur, in an election campaign, made a statement which is absolutely, dangerous for the very security of the nation, unity and peace of this country. And it's clearly attracted under Section 153 of the IPC and 124A, sedition. He said, Desh ke gaddaro ko, goli maro salo ko. Now, this was a clear cue to people. That's why the Election Commission barred him on 30th January from addressing BJP rallies and ceasing to be a star campaigner for 3 days. On 28th of January, next day, Mr. Parvez Sahib Singh, Member of Parliament of BJP, in an interview said, and this is equally provocative and horrible, these people will enter your houses, rape your sisters and daughters, kill them. This is time today. Modi ji and Amit Shah won't come to save you tomorrow. This is the second most provocative statement on 28th of January. Thereafter, the UP Chief Minister, Mr. Yogi Adityanath, in a series of election rallies, said, where Boli does not work, Goli does. And, EC issued a notice to him on 6th of February 2020, but by then the campaign ended that very evening. Now, this and many other statements, many acts of commission and many acts of omission, to my mind, have been completely glossed over by the police, the investigating teams, prosecution, and sadly, the judges across Delhi and the High Court and the Supreme Court. They should have asked the Delhi police. They are not living in ivory tower. They knew what was happening. And it's a matter of great sadness that you are fastening the entire responsibility on these young children, young students. Sharjeel Imam is a PhD student. He has got such fantastic degree. None of these students have any criminal antecedents. They were not trying to throw, a democratically elected government out of power, nor were they trying to dismember this country. India is too big for any group of young students to dismember. So, to my mind, the very argument of prosecution in this case, that there was a conspiracy to, cause riots, conspiracy to kill people, conspiracy to damage public property, all that, to my mind, really does not wash. And judges have really glossed over these.
So
And I'm
you
really
think
surprised. I'm really surprised that why emphasis was not paid on these facts by the counsels arguing on behalf of these accused.
Are you suggesting that the counsels arguing on behalf of the accused did not handle the case as well as they should have?
No, I'm not suggesting that. But the judgment does not show any reference to this argument. And to my mind, this is absolutely important to show that the prosecution theory from the word start is a completely bogus theory.
So you don't accept the claim made by the judges yesterday that there is a prima facie case against the two that is true. Prima facie true. You don't accept that at all.
See, judges perhaps have not even interpreted the provisions of the UAPA Act properly. These persons, even if they are charged, let's say at the worst, they are not guilty of terrorist acts. They have not used any bombs or any, dynamites or any other inflammable material or,
Can I interrupt there? The judges have said that there is no need for actual physical violence for the UPA Act to apply. They say the clause by other means as well covers the fact that these were perpetrators who had conceived of the plot. The conception is as guilty as the act.
No, that's absolutely wrong. By any means whatsoever, used in that expression of definition of terrorist act, section 15, you have to read it justem generis. That's a legal principle. You cannot read it in isolation. These people are charged at the most of using words, oral or written, maybe text messages or other messages, or maybe speaking out before some group of people. The mere words cannot be compared to bombs and firearms. The judges are completely wrong in saying that this is therefore a terrorist act. To my mind, these are not terrorist acts.
So you're saying that the judges have misread the UAPA Act?
Terribly, absolutely. I have no doubt about it. Because you can't, blame people for merely using some words in text messages or in, WhatsApp messages or in even emails or even, speaking at a particular place. See, two things are very important. One, that you must use these means like, firearms, bombs, etc., etc. Secondly, it must result as a consequence of that use into deaths or damage to property or security of the nation. You have to connect the two. Here, nothing is being connected. So it is very shocking that mere words which have not really resulted, because Sharjeel was not even in Delhi. He was already arrested in January. On 28th of January, he was taken into custody. And the police alleges this incident on 22nd to 24th of January 2020. So he is already inside, February 2020. So 1 month before that, he was already, in detention in some other case.
Let me ask you that pointedly. The truth of the matter, as you point out, is that Khalid was not in Delhi when the 2020 riots happened, and Sharjeel Imam was already in custody and had been so for almost a month. You're suggesting that the court should have borne this in mind when it claimed that there's a prima facie case against both of them. This, again, is something the court failed to do.
Absolutely. You see, court has committed manifest errors and many, many errors. For example, court has said that it is bound by judgment of the Supreme Court Union versus Najib or something. It's a 3-judge bench judgment, which was delivered by Justice Suryakant, present Chief Justice of India. In that judgment, the Supreme Court has very categorically recognized the principle that with even stringent provisions for bail under UAPA, or for that matter, earlier Supreme Court has said in TADA, Article 21 is sacrosanct so far as liberty is concerned. And therefore, when somebody has been in jail for a long period of 5 years and the trial is not likely to see the day, then there is every reason why the liberty is seriously in peril, and therefore such a person must be let loose. Now that judgment, these two learned judges say, is a very good judgment, but yet they say we will not follow it for no reason. See, the problem with Supreme Court is, Karan, and this is very sad, I would say, Supreme Court is consistently inconsistent, and its judgments and applicability of its own judgments as precedents or ratio decidendi depends on the constitution of following benches.
Let
Now
me
what
point
happened?
out to you, let me point out to you what the Supreme Court has said specifically about granting bail on the grounds that the two have been in jail for over 5 years. The court said this cannot be a trump card to override statutory constraints governing cases under the Unlawful Activities Prevention Act. In other words, the very act itself means that you can't use lengthy incarceration pre-trial as a grounds for giving bail.
No, judges are wrong because that's exactly what the Supreme Court judgment says in Najib's case. Even in some other cases, I mean, there are at least 3 or 4 cases. For example, the leading case is Shaheen Welfare, where they said that bail must be granted because person was in jail for almost 5 years in that case. There is Zoru Watali, that you can't conduct mini trial like this. There is Ranjit Sharma, NIA versus Zakur, Union versus Najib, as I said, Swaha Fazal versus Union of India. All these cases, whether under TADA or under UAPA, have really been very, very consciously engaged the attention of the Supreme Court on the part of right to bail, because the Supreme Court says that speedy trial is part of the liberty under Article 21. And if therefore we cannot guarantee a speedy trial, if prosecution does not, guarantee a speedy trial, then accused can't be kept indefinitely. 5 years is a long time. Now here what happened was, the FIR was sometime in February of 2020. The final charge sheet, the 5th charge sheet, was filed in 2023. Who is therefore delaying? Naturally, the framing of the charge is bound to be delayed till the supplementary charge sheets are filed. The framing of charge began sometime in August of 2023. Now, are judges unmindful of this? I mean, it's shocking that judges have not cared to follow their own judgments, which is a 3-judge bench judgment, which was, according to me, binding on them. And there were no distinguishing features so far as this case was concerned.
Then let me ask you this. We can't, of course, attribute motives to the court, but that still leaves hanging in the air the question, why has the court ignored its own previous rulings? And as you cited a moment ago, it's not one ruling, it's perhaps 4 or 5 different rulings which clearly state that bail is the norm, jail is the exception. Why do you think the court has blatantly and deliberately ignored these rulings?
See, what happens is, Karan, and this is this is something really to be pondered by the nation. Many a times, these kind of sensitive matters, are dealt with little, I would say, a little differently by judges. There are various kinds of judges. There are judges who are fiercely in favor of constitutionalism, who are fiercely in favor of liberty, who really have a very broad concept of liberty, who understand constitution very beautifully. They are not necessarily anti-establishment. They are not necessarily anti-prosecution, but they do lay a great emphasis on liberty of citizens. They are citizen friendly. There are judges, on the other hand, who are, pro-establishment, who are pro-prosecution, and they generally lean in favor of, whatever has been fed to them by the public prosecutors or law officers, arguing these kind of sensitive cases, because these case has become, for the ruling party, and I would say a kind of a tin plate case, that they want to suggest to the country that the Muslims are out to destroy this country, and they are out to ensure that the stability and security of this country is seriously jeopardized, and that this country is divided.
Are you suggesting that these two judges have allowed themselves to be influenced by the government's thinking and the government's attitude and prejudice? Is that what you're suggesting?
No, I am not suggesting that. I am suggesting what is broadly what happens. You see, sometimes matters like this, bail is a toss of a coin. If these very facts, if this case perhaps were to go to another bench, it might take a diametrically opposite view.
But how can these two judges ignore a three-judge bench ruling which legally takes precedence over them? It's a three-judge bench which said that bail is the norm, jail is the exception. They blatantly and deliberately ignored that ruling.
See, what has happened is that they say, in fact, I will read that paragraph 32, where they say, in Union versus Najib, this court recognized a constitutional safeguard that cannot be ignored. Statutory restrictions cannot be applied so as to render the guarantee of personal liberty illusory. Then they make the mistake and say constitutional court can give bail irrespective of statutory restraints, they say. But they say that that decision does not lay down a mechanical rule. What is a mechanical rule? I don't understand English language. In para 33, they say that the said decision does not lay down a mechanical rule. Of course it does. Of course it says that UAPS section 38 subsection 5 is not really going to override the constitutional guarantee of Article 21. Yes, it does provide a very stringent procedure, but that doesn't mean that court should be oblivious to the totality of the facts. So judges have completely gone wrong, and then they say, look at this, in para 34 they said that contextual though constitutional inquiry is required. Now, having denied the benefit, they say that we will now go into an inquiry, and then they analyze, conduct a mini trial, and then they say that no, these two people are different. Frankly, these two boys stand on the same pedestal as others who have been released on bail by the Supreme Court.
You're making 4 or 5 very important points. I want to very quickly sum them up for the audience. You're saying at multiple levels, the two judges handling the Umar, Khalid and Sharjeel Imam cases have erred. They erred in distinguishing between these two and the other 5 accused. They erred in concluding that the prima facie allegation against them is prima facie true. They erred in denying them bail on the grounds that the UAPA Act doesn't permit bail to be granted. They erred, in fact, in blatantly ignoring and setting aside a 3-judge bench which lays down the norm that bail is the norm, jail is the exception. At multiple levels, these judges have erred.
I have no doubt about it. The judgment is really flawed, both in facts and in law. Both in facts. Frankly, judges are not allowed to conduct a mini trial that they have done, to write a 147-page judgment and then dissect. What do they say in dissecting in para 98? Sharjeel Imam and Umar Khamid, prosecution material comprises direct and corroborative contemporaneous evidence, including recoveries, digital communication trail, and statements indicative of managerial responsibility.
But hang on a second. If this judgment, as you say, is completely wrong, if it's really flawed both in facts and law, what does that tell us about the quality of the two judges?
Well, judges are entitled to make mistakes. Judges are not gods.
But not so many mistakes.
It is there.
I mean, you cited 5 or 6 mistakes, each of which is a very serious mistake, and mistakes that have denied 2 people their liberty. What does that tell us about the quality of the judges?
I agree that this has seriously resulted in denial of liberty of these 2 young men. And it is a shame that what is happening in the country today, that, now virtually in entire country, judges are afraid to give bail to people, especially people belonging to minority communities. And, this same Supreme Court, I will tell you a very, interesting story. When that Anish Mishra, Mr. Teni Mishra's son, was charged with murdering 5 farmers in Uttar Pradesh by running his Thar vehicle, and a journalist was killed. The matter came for bail to the Supreme Court. Prashant Bhushan had briefed me. I was opposing on behalf of the farmers' complainants. And the Supreme Court, Justice Suryakant was heading the bench, said, why should we not release him? Because he has spent 1 year in jail. And I told learned judges that, yes, if you want to release him on bail because he has spent 1 year in jail, then lay down a law that all murderers, all persons who are in jail for 1 year will be entitled to be released on bail. And they released him ultimately, saying that trial is likely to take time because prosecution has a lot of witnesses, a lot of material to be considered. So we release him on bail.
But
Now,
that didn't apply to Sharjeel Imam as well as to Khalid Umar.
I will say something more shocking. There were several, I think 14 accused who were convicted in Sardarpura massacre in Gujarat 2002 riots. Convicted. And they were given life imprisonment. A bench of three learned judges headed by Justice Bobde released them on bail, saying that we will send them to Madhya Pradesh on an experiment basis. Now, who has seen whether they are in Madhya Pradesh or they are in Gujarat? But convicted persons who had killed large number of people belonging to minority community were released by the Supreme Court. So, Supreme Court.
I must interrupt you. Once again, you're clearly saying, not just suggesting, you're clearly saying that judges have a problem granting bail to members of the minority community, particularly Muslims. That reflects the attitude, it is widely believed, of the Modi government. These are very serious implications about the quality of justice our Supreme Court is handing out.
No, it's not just Muslims alone. Anybody and everybody who is today arrested by investigating agencies, especially ED, or the police making wild allegations of all kinds of sedition, etc. Nobody really gets bail in the country. From the trial court to the high court, ultimately it is Supreme Court which protects in large number of cases. But judges are not willing today to consider that and follow the principle that bail is a rule, jail is an exception.
But in this case, the court has, however, said that both Khalid and Imam can again appeal for bail after the completion of examination of the protected witnesses or after 1 year of Monday's order, whichever happens to be earlier. How meaningful is that?
Absolutely. I think it's really a mirage, because when they apply, then they will have to go through the same rut. The trial court, high court, and the Supreme Court. I don't know whether they'll ever get it. Frankly, they would be well advised to seek a review and file a curative petition against this judgment. To my mind, this judgment is so wrong that it deserves to be, reviewed, or at least review will go to the same learned judges, but the curative will go to 5 learned judges, and they should seriously reconsider. This is not how you deal with liberty of citizens.
So that is your advice to the counsel who appeared for Umar Khalid and also for Sharjeel Imam.
I'm not here to advise anybody. I'm saying that this judgment deserves to be, recalled in a curative petition. Because
let me put this to you. Is there a possibility that the court may have been adversely influenced by the fact that only very recently 8 United States lawmakers have written a letter urging India to grant bail to Umar Khalid as per international law? Could the court have been influenced by that fact?
I don't know whether it, and I don't feel that this kind of a letter should have any value so far as our system is concerned, because we don't write about what is happening in their country. So those I think people were not right. But all the same, I would say that it would have no impact. As I said earlier, the judges have given the judgment. They have done it bona fide. They have done it because the material that was presented to them perhaps made them think that yes, there is a prima facie case. But even if you reach a conclusion of prima facie case, the satisfaction required to say that there is a prima facie case against them under UAPA is extremely, extremely rigorous. And that rigorous satisfaction requirement is not discharged here. Merely saying that there is some material doesn't mean that you have accepted the version of the police.
But this is yet another error made by the judges that you're pointing out. This must be the 6th such error that you pointed out.
Yes, you have, because the greater degree of satisfaction is required. That satisfaction, in my view, I have read the judgment very carefully twice, all 147 pages. But I don't think that the judgment really has discharged that burden which is cast upon them to come to a conclusion that there is a prima facie case against these two persons.
Now,
if there was, then it was against all, because there is a common FIR. You see, remember one thing. When the first FIR was filed, they were not charged under UAPA. It was only 1 month later that, second, when the charge sheet was brought up, I mean, second FIR was filed or charge sheet was filed, that they first spoke about, this kind of UAPA and this kind of wild allegations about, threat to India's security, etc., etc. First was simple section 147, 148, and 149 of the IPC. So, and as many of them were not even named in the first FIR. So I don't know. I mean, this raises a very serious question about administration of justice, and especially the role of the law enforcement agencies, who are expected to be fiercely independent. They cannot, do this. You see, ultimately,
Let me ask you that very serious question. After the way the judges have treated Khalid and Imam, what is your opinion of the way the Indian judiciary handles the liberty of citizens of India, particularly when they are faced with mere allegations of grave offense? Because these are still only allegations, nothing more. So, what is your opinion of the way the Indian judiciary handles the liberty of citizens of India? It seems to me that if they can make 5 or 6 gross errors in granting bail, their attitude to the liberty of Indian citizens is pretty cavalier and casual.
I over years I have felt I was a lawyer for 48 years till I quit in July of 2025, as you know. And one of the reasons why I quit was because I felt deeply disappointed in the way judiciary is functioning. And there is no doubt about the fact that the justice is very skewed. Justice delivery is very skewed, and the rich and the powerful have gotten away with reliefs which they should not have gotten away, and the poor and those who are, not coming from good background, have suffered in the judicial system. I mean, you just can't allow these kind of things to go on. Judges have to be
This
conscious.
is a damning indictment of the judicial system where everyone should be equal regardless of whether they're rich or poor, powerful or not influential at all. This is
Yeah,
a damning indictment.
yeah, it's really I mean, there are cases where Supreme Court has protected people by granting bail in 32 petitions, in Article 32 petitions directly. And, forget that. What is happening today is that judges must really take a look at the situation which is prevailing in the country. There is an atmosphere of fear. And ultimately, whatever one may say, they may be right, they may be wrong. The present government does not tolerate any kind of a dissent, any kind of a protest. And protest on CA issue was something which was really against the very core of the philosophy of the ruling party. That how can, minority communities stand up and, protest against what we have tried to do. As you know, that the cabinet, I think, approved it sometime in January of December of 2019, the CA. And as soon as that was approved, protests started across the country. Now, they may have felt seriously, the minority community members may have felt that CAA might really not only disenfranchise them, as is happening in Sir, but really might make them, non-citizens of the country. Now, that was a genuine fear. Government had a duty to allay those fears. I have no doubt government doesn't want to throw out 20 crore Muslims out of this country.
It can't. It
No.
can't.
Yeah,
It
and it
simply
doesn't
can't.
want to. It doesn't want to. I give them a marks for that they don't want to do that. But at the same time, if a sizable section of the community feels, maybe wrongly, let me assume in favor of government, that they misunderstood CAA provisions, then it was the duty of the government to really persuade them, tell them that we are not going to do something which is going to really be existential threat to the community. Now, that is the background in which all these happened.
Let me ask you 2 more questions. How do you view the fact that Gurmeet Ram Rahim, the Dera Sacha Soda chief, has been granted 15, not 1, 2, 3, or 4, but 15 paroles since his conviction? And remember, he's convicted in 2017, whilst Khalid and Imam are refused bail and have spent over 5 years in jail when they are still legally innocent.
Well, uh, uh, I can only say that Umar Khalid and Sharjeel Imam cannot help the ruling party win elections. in couple of states, whereas the gentleman that you named, everybody knows, has a very strong base in those states of especially Punjab, partly Himachal, Haryana, and he is a big vote bank.
This is yet another serious indictment of the Indian system, not the judiciary this time, but the Indian system. This is a total farce, if I can use that term.
Look, one has to be very realistic about what is happening in the country. You can't just gloss over the fact. You can't close your eyes to what is happening. Ultimately, unfortunately, opposition is so weak that the ruling party is able to get away with anything and everything that they do. And as a result of that, it tramples over the constitutional and fundamental rights, as also the basic human values of the citizens.
And
But
this is where the judiciary is needed to step in, and this is where the judiciary is clearly failing to do so.
I have no doubt that judiciary is clearly failing to do so. I have no doubt about it. And I'm proud of my judiciary. Let me tell you, as I have repeatedly said, that my
You
father.
can't be proud of the judges who handled the Umar Khalid Sharjeel Imam case, because you've just pointed out not one or two, but maybe 5 or 6 gross errors that result in 2 people who are still legally innocent continuing to be incarcerated. They've been in jail for 5 years. They'll stay there for another 2 or 3 more, who knows how long. And you can't be proud of those judges. You've already made a case for saying that they're bad judges.
No, I am not going to say that they are bad judges. They have made bona fide errors. Judges always don't give the correct judgments. They are
Bona fide error surely can't include misreading and misunderstanding an act which is there in
It
cold
all
print in
depends.
front of them.
As I said, it all depends. As I said, ultimately what happens today is that a large number of matters in Supreme Court are dependent. The outcomes are dependent on which bench is hearing the matters.
Even sadder.
And that
Even
is
sadder.
and that is a very serious, I would say, flaw in the Supreme Court. This matter could have gone to any other bench. Senior judges, I mean, Justice Arvind Kumar and Justice Anjaria are not very senior judges. So it could have gone actually to first 5 benches. It should have really gone there, looking to the seriousness of the matter. But it doesn't happen. So, the things are, I don't know how to put it. Ultimately, these are matters for which the Chief Justice of India, his brother judges, sister judge, and the bar all have to sit together and have a brainstorming session as to how we can protect our citizens. How
Tell
we
me
can
something else. After the way the bail application of Khalid Umar and Sharjeel Imam has been handled, is this a black day for the Supreme Court?
No, I want it. There have been black.
Should the judges of the Supreme Court be hanging their heads in shame for the fact that they failed to do what you believe was their duty?
No, I won't use such harsh words. As I said, judges are entitled to make mistakes.
Not so many.
And it is our
You
duty
pointed
to
to 6 mistakes. Surely they're not entitled to 5 or 6 mistakes.
No, they can. Ultimately, it's their conception of the facts and law. To me, it is wrong. To many other people, it may be that they have rightly decided. So
Let me then end by pointing out what Umar Khalid apparently told his partner Bano Jyotsna Lahiri. He said, "Ab yehi zindagi hai." Is incarceration in jail the only realistic future that he can now look forward to?
Well, I can definitely say one thing, that I cannot guess when he will be able to come out. I cannot guess that. And this 1 year that Supreme Court has spoken about, I don't think anything will happen at the end of 1 year. And frankly, if they had to give 1 year, they could have released him today. What's going to happen between today and 1 year? There is no allegation against him that he's tampering with witnesses. There is no allegation against him that he's likely to indulge in other criminal activities. He has a very unblemished past. So if judges could give that relief, ultimately after writing 147 pages that you reapply after 1 year, you might as well give it to him today. So that is a contradiction in their judgment, according to me.
Yet another error, isn't it? Yet one more error.
No, I think they should have been mindful of the fact that these are young people. They are likely to be influenced. What is wrong? See, ultimately, look, as a person who feels that a particular law is unconstitutional, like CA, and I have a right to protest against it, what is wrong about it? What is wrong? Nobody really knows how the riot started, and we will never know. Because, look at 1984.
Let's not go
Congress,
to 1984.
no,
Let's
I'm
end
just,
with the point you're making, because I
no,
think it's a
just a sec.
fundamentally important point.
No, Karan, it's important. 1984 or 2000 Delhi riots or 2002 Gujarat riots, they happened. Why? Because, governments were responsible for them. Likewise, we would never know what really went behind the starting of these riots. Who was responsible? As I said, that the kind of statements the most powerful politicians of Bharatiya Janata Party made, did they result in riots? We don't know all that. So, and we will never know because police is not independent and they will never present a correct picture to the judges. So, what can judges do? Judges are not going to investigate themselves, but judges should have been mindful of these statements, should have been mindful of the fact that people were encouraged to indulge in violence.
And that mindfulness was missing.
Yes, that was definitely missing
We've ended
at
up
every level
pointing
of
out,
judiciary.
I've lost count of the number of errors you pointed out, but by my estimation and by my memory, it seems you've now crossed 6. You probably pointed to 7 or 8 serious errors. And that is why you say that this decision not to grant bail to Umar Khalid and Sharjeel Imam is completely wrong. You say it was really flawed both in facts and law. And as you pointed out, there were many, many, many errors. It's a sad day, I would say, for India's legal system. Thank you very much for the time you've given me.
And sadder day for these two persons who have unnecessarily, according to me, spent 5 years already in jail. They should never have been in jail.
Dushyant Dave, thank you very much for the time you've given me. Thank you very much for very boldly, bluntly, and fulsomely stating your reservations and your criticisms of the way the two judges have handled this case. I'm deeply grateful. Take care.
Thank
Stay
you so
safe.
much. Thank you very, very much.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.